since we're on TV, I'll say, I'll say that I'm Jeff Hasley. Currently, they're calling me the Kinder Institute Chair of Early American History here at the Kinder Institute. So we've not done this year. I've done this statement thing this year, and since we're taking up a mildly current, mildly controversial issue. I thought I might make my little statement that I sometimes make about the origins and purpose of the Kinder Institute of Constitutional Democracy. So, and by the way, this is like a version, 4B brief, right? Founded in 2014, the Kinder Institute is a joint project by members of the University of Missouri Political Science and History Departments and the College of Arts and Sciences, in cooperation with other scholars across campus. It is dedicated to research, teaching, and community engagement on the subject of American political thought and history, seen in a broad global context and from a wide variety of perspectives. Our goal is to prepare students for the future of American democracy by equipping them with knowledge of its past. The Kinder Institute, as many of you know, was made possible by a generous gift, actually more than one now, from Rich and Nancy Kinder and their Kinder Foundation in Houston, Texas. And people don't have to give their money to the study of history. So I say that's a great thing to do, because there's a lot of other things people can give money to, and this is a good one. At least we like this. Our hope at the Kinder Institute is to teach and learn about American constitutional democracy as the founders created it, but not just that. We want to understand the ideas that inspired the founders as well as those they disagreed with and over. We want to understand our republic's shortcomings as well as its accomplishments, the changes it has gone through, as well as its eternal truths. So that's a little statement about what we're about here, and I hope everything that happens. I think everything that happens more or less falls under that general head. Anyway, today I have the privilege of welcoming one of my oldest friends in academia, and probably in terms of academic friends, my oldest friend in academia. Not oldest. Relaxed, and not including professors I had in college. That's sort of like, right? Rosemarie Zagarri, university professor, currently university professor of history at George Mason University. Because Rosie was literally the only historian I knew at the time I organized my first conference panel in something, probably the actual year is probably classified. Rosie was so kind as to be the first commentator on the first conference panel that I ever organized. We've had a number of other associations since then, and she's also has become one of the most accomplished and versatile scholars in the field of early American history. She started out studying constitutional history under Edmund Morgan at Yale, producing her first book, Politics of Size, Representation in the United States, 1776 to 1850 from the Colonial University Press. Still one of the few works to address the conflict and debate that actually divided the Constitutional Convention much more than a lot of the ones that we argue about since. There's a lot of things that if you are around constitutional studies, you would think they would argue about more. They argue about hardly at all, but the size of the representation, the size of the republic, and all that was things that they actually did argue about. And Rosie's book is actually one of the best things that you can read about that. Then, as part of her studies of histories of the American Revolution she was working on, Rosie became one of the pioneers, term, whoever comes just after the pioneers, of early American women's history, right? I mean, I was going to say the settlers of early American women's history. What's that?
First generation.
First generation. Producing some of the important early articles on the concept of Republican motherhood, something that's gone into the textbooks long since, and producing a biography of the historian, playwright, and revolutionary activist Mercy Otis Warren. It's still the best work on a little-known figure who ought to be much better known. You might call her the non-reactionary Abigail Adams. That people know a lot more about Abigail Adams. From there, Zagarri took up political history in the traditional form of voting in elections, but combined that with her work in women's history in a really kind of epic-making way. It led to her involvement with the New Nation Votes Project that recovered early American voting returns that I was also involved with, and to be lead historian on mapping early American elections. Both those funded by the National Endowment for Humanities, and we probably should have put it up on the screen, but you can find that at earlyamericalelections.org, and it's an amazingly beautiful site where you can map all these old votes. Most importantly, that work led to the publication of one of the most widely read books in all of early American political history outside of founder biographies, and that is Revolutionary Backlash: Women in Politics in the Early American Republic, published by Penn Press in 2007, where Rosie went into topics that had really only been things that had been almost trivia questions before that. Rosie made very central as how women lost the vote, had the vote, and lost the vote, what that all meant in early America. Since then, she's moved on to transnational and transimperial history with the project on the Thomas Law family. And because of all this work, Rose has also received many grants, awards, and honors, which would take up too much time to name, so I'll just throw out two. She was Thomas Jefferson Chair of American Studies at the University of Amsterdam, and was the president of the Society of the Historians of the Early American Republic, where I got to see Rosie many times over the years, because that was the only place we could afford to take our family vacations. was to go to that conference every year. Rosie, so I feel like my children sort of grew up seeing Rosie once a year. So it's great that we're now both here with our children having grown up. It's great to have Rosie here. Rosie also, I should say, I forgot this, is a native St. Louis. So you can also get that home feeling. And let me just turn it over to Rosemarie.
Thank you so much, and it is wonderful to be here and to be among fellow Missourians, or at least I guess I'm an honorary Missourian.
Rosie, microphone.
Oh, I'm glad to be here and I'm an honorary Missourian. Okay, so I guess what I'm going to talk about today is probably something that you don't need to be embarrassed about saying that you never heard of before, or maybe you, like I, never heard of it until recently. I guess I was first made aware of it during the election of 2020, when this Independent State Legislature first was floated as a way of sort of invalidating some of the ballots in certain key states that were collected during that election. But there's a history, a prehistory before that, and there is a future to this Independent State Legislature. And it is a very important concept, though it is a concept that unfortunately is not easily penetrable, that I'm afraid is rather obscure. And so I'm going to have to ask you to bear with me, because I don't think I'm being engaging in hyperbole to say that in the upcoming case of Moore versus Harper, which the Supreme Court will hear this coming session, if the Supreme Court upholds this theory, it will radically change the entire nature of our constitutional democracy. And I will let you judge for yourself whether you think it will be a good change or not. But I think that it's absolutely critical to understand the historical basis for opposing this theory, not to mention to at least get you familiar with the reasoning as to why certain justices on the Supreme Court currently are thought to be in favor of this theory or supportive of this theory, and to understand the arguments that will occur in this Moore versus Harper. I gave you a handout, but for those who are watching online, here's the handout. I want you to understand, to go back to our US Constitution, much invoked but seldom understood, okay? And to the relevant clauses for a discussion of this independent state legislature theory. If you see on your handouts and on the screen, Article 1, Section 3 talks about the election of senators to Congress, to the upper house of Congress. And originally, if you recall, in the 1787 Constitution, senators were elected by state legislatures. This was changed in 1913 with the 17th Amendment, okay? But it's relevant to our discussion to understand that this was the case in the Constitution. Even more germane, Article 1, Section 4, called the Time, Place, and Manner Clause. It is the clause that specifies how members of Congress, members to the House of Representatives, are going to be elected by each state. And it says that the state legislatures, each state will describe and define the times, places, and manners of holding elections for senators and representatives. Okay, but, and here's a key caveat, that Congress may at any time by law make or alter such regulations, except for the place of choosing senators. Okay, third relevant clause, Article 2, Section 1. Each state shall appoint in a manner as the legislature thereof may direct a number of electors. And so this is in regard to the election of presidential electors. And this gives the state legislatures the power to decide how the electors will be elected. As you know, because of our very own electoral college process, which still is in existence, unfortunately, we in the United States do not vote directly for president. We vote for the presidential electors, okay? And then the presidential electors cast the ballots. I'm sorry if I'm being very basic here, but you need to understand these very basic issues. Otherwise, this whole thing won't make any sense. But in any case, it's up to each state legislature to decide how the presidential electors will be elected, okay? And now in all the states, the people elect the electors, and then the electors vote for president, but initially, a lot of the state legislatures actually voted for the presidential electors, although this quickly changed. In any case, okay, this is just the basic, framework, the basic factual information that you need to know before we understand what is going on here. So what's at stake in Moore versus Harper? Okay, this is a case from North Carolina. It's a case about redistricting. As you know, every 10 years, the House of Representatives of the United States is redistricted based on the new census returns. As you can see from the Constitution, under the Time, Place, and Manner Clause, it's up to the state legislature to determine, the districts. And so that has been the case, although traditionally it has also been the case that the state courts, the judicial branch, has the authority to weigh in, and if those districts are found to be inequitable in some way, they can overturn or overrule the legislature's redistricting plan. So in North Carolina, in this past year, the North Carolina State Court overturned the North Carolina's districting of its members of the House of Representatives. Initially, the North Carolina appealed to the Supreme Court. They didn't initially take the case, but then over the summer, they've decided to take the case. And as I say, Moore versus Harper is the case, and it will be argued this fall. The question here is, does the legislature of a state have supreme and absolute and independent authority over determining the guidelines for electing U.S. representatives? Do the courts, in other words, have any role to play in these matters? And The independent state, to cut to the chase, the independent state legislature theory says that courts have no role, that the legislatures are supreme, okay? All right, just want to get that out and on the table because this is the theory. Why do historians of the founding period have a problem with this theory? I will tell you. Okay, all right, so we have to go way back to the late colonial period and to remind ourselves or refresh our memories, or maybe you didn't ever learn this, but in the colonial period, of course, all the North American British colonies had a government that was prescribed under their charter, that was allotted to them, that was granted to them by the British monarch. Each of the 13 British colonies had slightly different forms of government, but each of them had a legislature with an upper and a lower house, and each of them had courts, and each of them had a governor. Throughout the colonial period, there was intense rivalry, intense antagonism between the colonial legislators who were elected by the eligible electors in each colony, and the governors who in most cases were appointed by the monarch, or in a few cases they were appointed by the proprietors, but they were usually outsiders, not from the colonies, came in for a few years, tried to make a lot of money, and leave. Throughout the colonial period, the people's representatives in their, especially the lower houses of their legislatures, tried to seize power, to get more power and privileges from the colonial governors, but the colonial governors kept trying to slap them down. These antagonisms came to a head in the 2 years before the American Revolution, between 1774 and 1776. These are the years when Britain had imposed a series of increasingly of policies that were increasingly regarded as hostile to the colonists, as undermining the colonists' right to representative government, of, yes, taxing them without their representation, and in other words, taking away what the colonists considered their traditional rights and privileges as British subjects, okay? So in this period, beginning in 1774, after the passage of a particularly harsh series of measures, the so-called coercive or intolerable acts, the colonies began to band together and really unite in their protests against Great Britain. But perhaps what is even more interesting, or at least more relevant for our discussion today, is what was happening in the individual colonies with regard to their legislatures. The colonial legislatures had been in the vanguard of leading the protests against these British policies. Individual colonial legislatures had submitted resolutions and petitions and addresses. And more often than not, the colonies had worked individually through their legislatures to protest these increasingly harsh British policies. And by 1774, many people in the individual colonies had become so disaffected from Great Britain that they were searching for alternative ways to continue to support representative government within their colonies, but to show that they had lost confidence in their official governments, And so what they began to do was hold extra legal assemblies, provincial congresses. And these, I will say, between 1774 were held in almost all the colonies, and they were truly independent legislatures. They had no explicit authorization from any charter or grant. They were instead of the people's making. They were authorized by the people. They were elected by the people, and by the people, yes, I mean white male electors with property. But yes, they were legislatures that operated outside the boundaries of the royal governments within the colonies, because the official royal governments were losing the people's confidence. They were becoming delegitimated. And so the people wanted to pursue and continue to pursue representative government and to continue to preserve the rule of law and to continue to have order within their colonies, even as the situation was deteriorating to the point of taking up arms against Great Britain. But they did this within their colonies. These were extra legal bodies. Of course, that's what American historians call them. The British would call them illegal bodies, but they were of the people. And these bodies continued to raise taxes, to raise arms, to muster troops, to get supplies for the potential conflict, the potential coming conflict with Great Britain. So I emphasize this because there was a time before the American Revolution where something called an independent legislature did exist. It wasn't in the colonial period, but it was in this period, in the 2 years immediately before the Revolution. But then, in May of 1776, right as the Continental Congress was authorizing the writing of the Declaration of Independence, which would be issued in July, the Continental Congress did something equally important, at least in my view. They sent missives to the individual colonies, which we now start to call states, and they said, write a form of government, produce a form of government that most conduces to the happiness of the people in your colony / state. So this was the beginning of the break, not the beginning of the long-term beginnings, but the official break, because each of the colonies were moving from colonial status to the status of states. And to do that, what they did was write their state constitutions, their first state constitutions. And I always complain because I think state constitutions get short shrift in the teaching of American history and in our knowledge of politics today. But state constitutions are absolutely essential to the preservation of our rights and liberties. They affect our daily lives in innumerable ways. I think now, post Roe versus Wade, there is a little bit more attention to the importance of the state constitutions, but I think, for a long time, we've only thought primarily about constitutional government at the federal level, at the national level, but these state constitutions were absolutely essential. The individual states said, oh, okay, we have a chance now to create a government from scratch. These were like laboratories for creating new kinds of representative structures of government, new institutions of Republican government. And so each of the states wrote a state constitution, but each of them did it differently. And in some cases, they did it very differently, which makes it very difficult to generalize about these early state constitutions. Nonetheless, I will make some generalizations, but you just have to understand that there were a lot of differences between these constitutions. In any case, most of these early state constitutions were reactions against what they perceived as the abuses of the royal governors and of Great Britain. So what were the characteristics of this first wave of state constitutions, which were written in 1776 and 1777? Well, the biggest and most dramatic change was a stripping of the governors of authority. Governors in most of the states lost their veto power over legislation passed by the legislatures. In most states, the governors were elected by the legislature. So essentially, they were creatures of the legislature. They were beholden to the legislature. Governors lost their appointive powers, their power to appoint subordinate offices, judges and coroners and justices of the peace. So these governors lost a lot of their power. Why? Well, the governors had been the bad guys, the local authority of the crown in the period before the American Revolution, and they reminded people of the biggest bad guy, the king, right? So they wanted to strip the executive of most of its powers. Who got the powers? The legislatures, these new state legislatures. And legislatures were and are great things. They do and are supposed to reflect the voice of the people. They are supposed to be, and they are, responsible to the people, accountable to the people. They express the people's grievances. They know what burdens, tax burdens people can bear. And so there was a move in this first wave of state constitutions to embolden, empower the state legislatures, to give them many more powers. Okay, so as I say, there's a lot of exceptions to this, or caveats, or asterisks, but those are the big general patterns. And this seemed great because what the colonists were doing in overthrowing Great Britain was overthrowing monarchy and establishing 13 separate Republican, that is small R Republican governments, that is representative governments, self-governing republics, under the auspices of a confederation government. So what linked the 13 states during and immediately after the revolution was a confederation, a loose union of states which were basically self-governing. With me? Hope you're not asleep yet, sorry. I know this is really like hardcore political history. In any case, okay. So at first it was great. These state legislatures were extremely responsive to the people's wishes. People don't want to pay their debts? Okay, let's either print a lot of paper money or abolish the state debts. People want to punish the loyalists? Oh, let's confiscate the loyalist property and not compensate them, certain minorities are not in favor, let's deprive them of their rights. That's, in essence, majority rule, right? Responsive to the people's wishes, directly responsive. In a lot of these, under these first wave of constitutions, the legislators were elected almost every year. In fact, John Adams said, where annual elections end, slavery begins. John Adams knows this quote. Anyway, the idea of legislators being highly sensitive to the people's wishes, needs, demands was foregrounded, was what was embodied in this first wave of state constitutions. And as I say, it's a reaction against what they perceived as the abuses of the crown and of the royal governors. But the states did not have legislatures governing alone. The states wrote constitutions. And in these state constitutions, the legislature was subordinate to the authority of the Constitution. The legislature did not exist, as those provincial congresses did, as a separate or independent institution. The Constitution created the legislatures in the states. It prescribed who could be elected, when they would be elected, how could they be elected, the apportionment of the legislatures, what was necessary for a quorum, how to pass laws. Legislatures after 1776 did not exist apart from the state constitutions that constituted them. That seems kind of redundant, but that is what happened, okay? It's very important to understand these things because otherwise you won't understand the historian's case against the Independent State Legislature Theory. Okay, so, but then by the 1780s, even as early as 1777, actually, as you'll see on this chart, a lot of Americans were having buyer's remorse. There was too much representation, too much of a good thing, too much democracy, some people said. Not everybody said that, but some people said too much democracy in these state legislatures because there was no institutional checks, or very few, I should say, not no, but very few institutional checks. Ultimately, the people always were the ultimate check on the legislature, and these frequent elections were the way they could most easily do that. However, at this time, the idea of judicial review of state courts overturning state laws was in its infancy. It was being formulated. It was part of the experimentation going on in the states, okay? You had some very early decisions. You had in a couple of states, in Pennsylvania, a council of revision, and in New York, a council of censors, and in New York, a council of revision that operated in a way that could overturn state laws. So you had the nascent beginnings of this concept of judicial review, what we call judicial review, what John Marshall called judicial review, but it wasn't a full-blown concept. So my point here is that the state legislatures were, like as Madison might have said, running amok. There were few institutional checks, and because the governors were so weak, because they were beholden and often elected by the state legislatures, because they usually didn't have the veto power, they couldn't check the power of the state legislature. So by 1777 and through the time of the Constitutional Convention in 1787, many of the states, as you see in the second wave, rewrote their state constitutions. They rewrote their state constitutions and began putting in more kinds of checks on the legislature's power to curb legislative supremacy. Let's see how I'm doing on time here. Okay. How did they do that? One, they did that first by making more of a distinction. I'm really sorry, I'm getting really into the weeds here, but it's really important. Okay, or at least I think it's important. First they did that by many states having separate bodies from the state legislature write the state constitutions. The first state constitutions were often written by those provincial congresses or who were themselves like the existing legislature. Now you began to have separate elections for conventions specifically meant to draft the state's constitution. Along with that, Massachusetts and New Hampshire following it soon began to pioneer the idea of ratification of the Constitution by the people, that is submitting the Constitution to the people who could say yes or no. This is the fundamental document which will govern our state, which establishes the structure of government, which establishes the constitutional principles by which our state will be governed. Both of these things contributed to an increasing differentiation between what you would call statutory law and fundamental law. Then, I'm so glad that you're shaking your head. Yes. Sometimes I think I'm the only one who cares about this. So. Statutory law is, of course, the laws passed by the legislature. Fundamental law is what came to be understood to be embodied in these written state constitutions. By the way, just having a written constitution was an innovation because, if you know anything about written, they didn't and don't still have one single document that they call the British Constitution. They have a collection of unwritten norms, of common law, of laws passed by Parliament, but they don't have a single one document that is their written constitution. So having a written constitution opened up new possibilities for understanding a difference between constitutional law and that is as fundamental law and the laws passed by legislatures, and for the idea of making sure that the laws passed by the legislature are in conformity with the principles in the Constitution, whether that be the state constitution or ultimately the new US Constitution. Okay, so this is an important development. Drafting conventions and ratification process, and not all the states did it, but they're moving in that direction. Some of the states in this second wave of constitution writing, and even more so in that third wave, started to take away powers from the legislature and give the governor a veto again. This seemed like a very bold and daring move because those nasty colonial governors had been very mean to the colonists, okay? And giving one person that authority just smacked too much of what the crown had, the power of the crown. Some states moved away from having the legislature elect the governor. Some states modified and gave to the governor more appointed powers. So the overall point here is in that second wave of constitution writing, and really by the third wave, very much so, there were checks imposed on the powers of the state legislature. In other words, to put it simply, many political leaders by the 1780s realized that state legislatures or legislative supremacy in the states was a dangerous innovation, and that there needed to be more institutional checks on the powers of the legislature, even though the legislature is the most representative branch, even though it is the people's branch, okay? And this goes along with the development of the idea of separation of powers, right? And the idea you need this balance between the branches of government to preserve the people's liberty. That if you have excessive power in any one branch of government, then you'll get corruption, you'll get an imbalance in the government. Okay, so moving right along. So then this, the excessive powers, this legislative supremacy or democratic despotism, as James Madison called it, did not go unnoticed by a lot of political leaders at the national level, most notably James Madison and Alexander Hamilton and James Wilson and many others. And as they were contemplating the crisis of the Confederation, as the Confederation government seemed to be losing authority, losing power, not being able to function, not being able, and again, you probably, most of you don't think about this, but the articles, under the Articles of Confederation, Congress had to ask the states to pass taxes that would then be submitted to the federal government. Well, you know, if it's completely voluntary, no coercion or sanctions involved, would everybody pay their taxes? And they didn't. They didn't. The states, they were busy. They had the economic depression. They were paying off their own Revolutionary War debts. You know, if they got around to it and had some extra money, they would send some to the Confederation government. So it was really bad. Sometimes the Confederation Congress didn't even get enough members who gathered together to meet to have a quorum to do business. They tried to amend the Articles of Confederation. You had to have unanimous approval by all 13 state legislatures. At least one legislature held out almost every time they tried to amend it. So they couldn't raise money. They couldn't regulate interstate commerce. They couldn't raise troops directly. They could, again, ask the states to please raise some troops to put down this rebellion. But, you know, it was an iffy proposition. So there are these problems that are caused within the states by the state legislatures having excessive power, overweening power. And then there are problems for governing this new United States, this new union of 13 states, because of problems in the states and the state legislatures having too much power. Now, James Madison's solution, and he convinced a lot of other people that this was the right solution, was not to reform the individual constitutions, although he was in favor of that. But instead, he, when they got together in 1787, scrapped the Articles of Confederation, contrary to the charge that they had been given to revise the Articles, and instead proposed an entirely new system of government. What is that there? Where am I? Oh, there we are, the Constitutional Convention. Okay, so Madison proposed an entirely new system of government that was partly national, partly federal, that is partly based on the states and partly having a strong centralized government, right? Okay, he didn't want to eliminate the states, he wanted to build on the power of the states. But that was a very difficult and challenging assignment he took up at the Federal Convention in 1787, because there were many people from a number of states who wanted to preserve the power of the states, to preserve their autonomy, to not cede power to a stronger, more centralized national government. Okay, so as you know, There was a long, hot summer in 1787, but a lot of the leading proponents of strengthening the government were absolutely convinced that that democracy was running amok in the states, that the state legislatures were too strong. Here's a couple of good quotes. John Francis Mercer of Maryland said, "What led to the appointment of the convention? The corruption and mutability of the legislative councils of the states." John Dickinson of Delaware agreed. He took it for granted that all of the convention were convinced of the necessity of making the general government independent of the prejudices, passions, and improper views of the state legislatures. Madison himself, of course, said, the state legislatures were sucking everything into a vicious vortex. And so there was strong sentiment at this convention for curbing the powers of the state legislatures by creating a strong central government that would definitely have the supreme power over the states. Now, again, there was a countervailing argument that had to be overcome. But it's crucial here that everything that was produced at the Constitutional Convention was a result of compromise between these two groups. And so that's why we have weird things like the Electoral College. You just have to know that. That's why we have, it's arguably the most original contribution to the Constitution, the system of federalism that gives a lot of power to the state governments, but also to the national government. But the question is, how could they balance these things? Oh, I will say one other thing about this. James Madison himself was so convinced that the state legislatures were out of control that he actually proposed that Congress have the power to veto laws passed by the state legislatures. Got that? Congress should be able, now that didn't go far. Among other things, legislatures were not willing to give up that much power, but he thought that the state legislatures were so out of control, legislative supremacy in the states was so powerful and so destructive that the National Congress had to be able to veto state laws. Again, I emphasize this in light of the theory we're trying to debunk, to discuss the historical origins, for lack of historical evidence.
Placed in context.
Yeah, placed in context, thank you. But there was a strong desire at the Federal Convention to limit and control the powers of the states, and especially the power of the state legislatures. But never once that I can see did the framers of the Constitutional Convention assume that the state legislatures would operate independently of their state constitutions. And we have, among other things, the Republican Guarantee Clause, which is the clause that preserves to each state a Republican form of government and protects it against invasions and domestic insurrections, right? A lot of times when historians focus on that clause, they focus on protection of the government against domestic insurrections and invasions. That's all true, but it's also guaranteeing a Republican form of government to each state. How do you guarantee a Republican form of government to the states? You do it by guaranteeing each state its own constitution. Republican government is created in the states by the state constitution, right? And if you look at the debates at the Federal Convention, this is a more explicit assumption of this clause than what the wording came out in the final Constitution. But the clear assumption was that in guaranteeing a Republican form of government to the states, you do it by guaranteeing them their Republican Constitution, or the Republican form of government through their Constitution, not through the independent existence of a legislature in each state. You get where I'm going. Okay, then we get to the nub of it here, okay? We get to the so-called elections clause, the time, place, and manner clause. And we get to that debate because Congress could have just said, Congress shall make laws concerning federal elections for each state or for all the states. They didn't say that. They said, if you look back to your cheat sheet here, they said that the time, place, and manners shall be prescribed in each state by the legislature thereof, but that Congress may at any time by law make or alter such regulations. So this was debated, although I have to say among the many issues that were debated, it was not exceptionally hotly debated. The question here then is that the states are getting the authority to establish the time, place, and manner of electing their members of Congress. If they don't do the right thing, okay, Congress can intervene and pass laws, all right? But you see, it's not an unlimited grant of power to the states or to the state legislatures to pass these laws. It's a grant of power that is supervised by the Congress of the United States, and that, in light of the entire U.S. Constitution, works within the structure of government, the constitutional structure of government within each state. And interestingly enough, okay, so here we get to how can the proponents of the independent state legislature theory argue that legislatures alone have the power to make these laws. They do a literal reading of the text that I have before you. The text says legislature. The text does not say state government. The text of these clauses does not say constitutional government in each state. It says legislature. And there are a number of Supreme Court justices that say if it says state legislature, they meant state legislature, despite the fact that it hasn't been read like that before. But that's what the argument is. However, the more you read in the founding period, as I have, and as a few people in this room have, the more you see that the term state legislature was actually a synonym for state government. So you have a number of examples, even in the Federalist Papers, where Madison describes the particular role of the state legislatures in the election of president and members of Congress. But in the same paragraph, he says, each of the principal branches of the federal government shall owe its existence more or less to the favor of the state governments. State legislatures is a synonym for state governments in Madison's usage here in the Federalist Papers. If you look at state ratifying conventions, in the Massachusetts Convention, you have Mr. Bishop in saying that each state legislature would make the regulations for the time, place, and manner of electing members to Congress. But if the states refuse to do their duty, then Congress shall do it. During the North Carolina ratifying convention, the very existence of the general government depends on that of the state governments. The state legislatures are to choose the senators. Okay, so you can multiply these examples and see that that term that looks so clear and unambiguous, legislature, state legislature, in the U.S. Constitution, actually in practice was used interchangeably with the term state government in the debates over ratification of the Constitution in 1787 and 1788. And I think it's really important that if we're going to debate this independent state legislature theory, that we understand that that term legislature was not as unambiguous as some people would like to read it today. Okay? But I'm not finished. That's not all. That's not all. In a more general sense, the very notion of Republican government, constitutional government, implies that the legislature is subordinate to and a creature of the state constitution. And, you know, again, in the Federalist Papers, Madison and Hamilton and others talk about, here's Madison in number 49, the people are the only legitimate fountain of power, and it's from them that the constitutional charter under which several branches of government hold their power is derived. The legislature cannot exist and does not exist separate from the constitutional charter. The Constitution in each state and in the U.S. government represents the original grant of power from the people. The legislature's authority is derived from that of the Constitution. Okay? One more thing. What did the state legislatures do during the first federal elections? Constitution was ratified 1788. First federal elections were held in the fall of 1788. First Congress met in Washington assumed the presidency in the spring of 1789. What did the state legislatures do when they read the text that you're reading here before you and saw that word legislature? Did they presume that only the state legislature should pass laws regarding the election of members of Congress or presidential electors? And the answer is they did not assume that. They assumed that the state legislature would make laws in accordance with the normal constitutional provisions of its individual state. They used the normal lawmaking procedures in their state to pass the legislation regarding the election of members of Congress, lower house of Congress, and of the presidential electors. And we have, in fact, a very interesting case in New York, where one of the few states that had supervisory oversight to the laws passed by the legislature, where the Council of Revision actually rejected an election law passed by the New York legislature. They actually rejected it. So we know that from the beginning, there was not ambiguity in the minds of the founding generation about whether the legislature was supreme in making federal election legislation. It was not. Laws were made according to the normal lawmaking procedures and subject to the oversight of the other branches of government, whatever existed at the time. Now, again, I will concede that the courts were still pretty weak at this time, and the governors had differing degrees of veto power, but they passed ordinary legislation subject to the constitutional constraints existing at the time. Okay? The only exception to this, the election of senators to the U.S. Congress. If you recall, it says that the Senate shall be chosen by each legislature. Interestingly enough, members of the founding generation read this and they knew that legislature meant something different there than it meant in the other two clauses. They knew that this meant that the legislature should act in its appointive capacity to appoint senators to the U.S. Senate. Now, as I said, this became moot once you had the 17th Amendment in 1913, where you had popular election of senators. But for the founding generation of legislators, they differentiated in that between the meaning of those same words, between the legislative function of the legislators in passing laws regarding the election of members of Congress and presidential electors, and the appointive function of the state legislatures in electing U.S. senators. So, where are we? Again, the case for this independent state legislature theory, and here's where, I'm not a lawyer, so I only know what I read. I have less confidence of this than these founding era documents, which I feel very confident about the evidentiary base about. But in any case, as I understand it, there have been probably maybe two cases in American history that did assert some kind of primacy to the state legislatures. One was during the Civil War, and one was like in the 1870s. They never set a precedent. They were never followed. The precedent for almost our entire history has been that state legislatures passed federal election regulations subject to the oversight of the other branches of government in their states. And that in the case, say, for example, of the North Carolina redistricting, it's perfectly appropriate for the North Carolina legislature to overturn the districting of the North Carolina legislature. Okay, so why are we even talking about this? Well, in the election of 2020 in Bush versus Gore, and again, as I understand it, there were 3 justices who, in their commentary, Rehnquist, Scalia, and Thomas, said that in certain cases, state legislatures could override the decisions of state courts. This is like, I don't know if it was a footnote or if it was just a throwaway line in their, when they're counting the ballots in Bush versus Gore, and they weren't sure about the hanging chads, and they're worried that it might go to the Florida legislature, but they were worried that the Florida courts might overturn what the Florida legislature said. In any case, this was just like tucked in there. But then in the election of 2020, as we know, there was a mad scramble to find reasons to allow state legislatures to have absolute primacy and supremacy in making the rules for counting presidential ballots, how the presidential ballots should be, whether mail-in ballots are valid, what the requirements for ballots were, or throwing out ballots. So this theory was floated again by, I should say, the Republicans, not the Democrats, in the election of 2020. And that's what's led in this past year to the Supreme Court taking this case of Moore versus Harper and relying, at least some justices, on this extremely literal textual basis in the Constitution for overturning over 200 years of precedent to elevate state legislatures to the position of absolute supremacy in making state regulations regarding federal elections. So there, I am happy to take questions. I can't promise I could answer them all, but there you go.
You ready to go first? Travis always wants to go first.
You want me to go first?
Well, I mean, nobody raised their hands. Or Bill.
Cold call. So you want me to go? You want me to ask a
If
question?
you have one.
I have many. Thank you, Rosen. That was tour de force laying out what is Byzantine and complicated. Can you maybe speak a bit more about, so on the one hand, Article 1, Section 4 has the states have a certain kind of authority, but the federal government can intervene. But then you also were talking about the authority of other state actors, like state courts, to intervene. It seemed to be you were suggesting, these are different variables that we should hold in our mind, and maybe the idea of state courts. So you gave us this tantalizing sense that in the 1780s, state courts are beginning to flex their muscles a bit more. How should we think about the authority under state constitutions of state courts to second guess what the state legislatures are doing in the domain of federal election law or anything else? And if we're trying to make sense of what Article 1, Section 4 means and what legislature means, what you think we should, it's a hard question.
No, but it's the basic theory of what a written constitution as fundamental law means in the United States and how it's evolved over time. So it is true that in the 1780s, many of the individual states did not have state courts that could overturn a law passed by their state legislatures regarding, say, the time, place, and manner of election. But if the theory of constitutional government in the United States that's embedded in the Federalist Papers, that's embedded in the whole notion of a written constitution pertains today, you have to understand the state constitution that exists today. And today, state courts have the authority under their state constitutions to review the laws passed by their individual states regarding any laws, but including federal elections. I mean, there's no reason why that should not be included. So it is the theory of constitutional government that is the most compelling argument here as to why the legislatures can't be independent or separate or supreme.
Bill?
Given that the Constitution says that it's Congress that can control the legislature, why do you need the other source?
Okay, do you think Congress today is going to pass a
I don't care
law?
what Congress can or cannot do.
They can,
I'm saying,
and they have passed laws
right,
mandating single district elections. They set the date for elections. So Congress absolutely has the authority. So if they can get enough votes in Congress to regulate this matter and to say that Congress has the ultimate authority, then that will do away with this whole challenge. Yes. Is that what you wanted me to get at?
well, I'm just saying, you're trying to make a theory, you're gonna reach a result.
Yes.
You read the language.
Yes.
Which tells you what the
Yeah,
result
you
is.
are right. You are right. And I will make another point here. It says Congress shall make a law. Do you think when the framers wrote that, they thought that Congress as an independent legislature could make that law not subject to possible veto by the president?
No, because it says by law.
Right. And it's subject to the Constitution. So- So the US Constitution itself uses the word Congress or legislature, and it's not assuming that it's an independent Congress or it's an independent legislature. The very notion of constitutional government implies the supervision of whatever existing other branches of government exist.
But student question, I think we had a student question in the back, or both, maybe two. I actually don't know the status of everyone here, but it's a student question. All right.
You mentioned during the discussion of the constitutional convention, how this came about and that, no laws were created for how federal elections will be conducted by the states. Why not?
It's-
Fear of centralized government or the desire to allow the states more freedom and independence?
Yes, yes. It's part of that balancing act I was trying to suggest. To, devolve power to the states or to keep power in the states. To placate those in the states who did object and continue to object to the strengthening of the power of the national government, but to sort of keep the ultimate cards with the Congress at the same time. I mean, it's like the supremacy clause or the elastic clause. When Madison didn't get his preferred version, that is a veto over state laws, the best next thing is the supremacy clause, the elastic clause. But here, what you have is, it's a compromise, and it says, okay, states, you do the right thing, and we won't interfere, okay? But if you don't do the right thing, like there was a concern raised at the convention or in the ratification debates maybe, what if the state legislature simply refused to pass legislation regarding the holding of federal elections? Well, then Congress would definitely have to intervene, right? So it's part of that balancing act that I've been talking about, giving the states a lot of power and autonomy, but reserving power to this new, strong, centralized national government if necessary.
Yeah, that part seems to crush it to me, but there and there.
So please correct me if I misunderstood, but there were two cases that I believe you mentioned where the state asserted its independence. I was trying to word that.
Yeah, this is where, I have my notes and I have just a few references here and I just don't know details. Okay, here's what I have. Okay, so McPherson, there was a case during an obscure Civil War case, I say, called Baldwin versus Trowbridge. And it was something about a Civil War soldier, do you know? A Civil War soldier voting.
Jonathan was nodding like Baldwin versus Trowbridge.
Anyway, where the legislature it inserted its independent authority, but it's during the Civil War, I think it's 1863, Baldwin versus Trowbridge. And then 1892, McPherson versus Blacker. And you're at the limits of my knowledge. I'm an early American historian, so.
My question would have simply been like, why wouldn't those create established precedents? But like I totally.
But they weren't. They haven't been precedent. They haven't been built on for over 200 years. Those were just sort of hanging precedents, like hanging chads, and nobody followed them. Nobody thought they were worth anything. You have the practice of state after state passing laws that are in conformity with their state constitutions for these federal election laws. So you have these two exceptions, and you have the text of the U.S. Constitution. And I mean, maybe, again, I'm not a lawyer, but that's what I think they got.
Okay, in the back, this person in the back in the middle is, go ahead. You, I'll go to both of you. I've been seeing you. Oh, it's yours. You were so well.
You mentioned the Civil War. As I remember correctly, certain senators and elected senators were not accepted by Congress. Was that based on their state constitution or on the general right of Congress to refuse to accept certain political electors in the list? What is the basis of that?
I don't know. No.
I'm sorry.
Civil War, no, sorry.
You mentioned the Civil War once, and that's why.
Yeah, no, I'm sorry. I just can't. I don't want to go where I don't understand.
We have one question from Facebook, just gonna go away if I move this anymore. I don't want to see any more Jordan's notifications.
You leave my girl alone.
Well, I'm trying. Would a state constitutional, this is from Michelle Morris, a colleague in history department. Would a state constitutional amendment be sufficient to allow the legislature in that state to take exclusive authority over voting in that
Yes,
state?
yes.
Okay.
Yes.
So she says I'm not recommending this. Okay, all right, well, let's keep that quiet then. Go ahead, Jay.
I'm not sure if I'm going to phrase this observation as clearly as I should, but I think your discussion of Article 1, Section 4 provides considerably more evidence for your argument than perhaps you're letting on.
Yeah,
So,
okay.
Article 1, Section
Please.
Article 1, Section 4 was originally discussed as a protection for the national government for the reason you mentioned earlier, which is if several states refuse to elect legislators or representatives, they grind the national government to a halt because they can't conduct business. Early after 1805, 1810, in response to the states using a variety of different election mechanisms, there was a question of codifying in the Constitution a single member district requirement.
Yes.
It obviously never made it into the Constitution as an amendment, but there was a secondary discussion of what Article 1, Section 4 meant. And I'm really reaching back to about 7, 8, 9 years ago, but if I recall those discussions correctly, there was explicit discussion that they were talking about the states in their constitutional capacity. In other words, they didn't care if the legislature
Yeah,
did
good.
something.
Oh, great.
It was the
1805, that's great. That's,
1805,
Wow.
1810, I might be able to resurrect
yeah,
some.
yeah.
The interesting question is, of course, 1842
Right,
is when, and the discussion completely changed by 1842 with respect to this.
right.
But
And so in
anyway, I think it's an early
1842, Congress does pass a law, not a constitutional amendment,
Right.
requiring single-member districts. So, Congress has asserted this authority at times, but, and they could again, but that's really interesting.
1967 is the last time they.
Yeah. Yes, but 1805, I'm gonna look at that.
Be somewhere in there. Don't
Yeah.
Don't hold me down for that.
Let's see, right here.
So forgive me if I'm stepping outside of your expertise, but I'm just wondering what the future impacts of the Supreme Court's accepting the Independent State Legislature Theory would be, just beyond the specific case of North Carolina.
Of districting?
Yeah.
So, I mean, what it means is that, and why I have the provisions for presidential electors here is that it could empower them too in terms of the electors. So it just means that you will have legislative supremacy. That, you know, why did this come up now? Because, and I mean, this is just the political, I think it's a political fact, I don't think it's opinion, that Republican legislators have passed districting laws that the state courts have overturned. And that means that legislators, and they could be Democratic legislators, could just pass whatever, they would not be subject to the oversight of the state courts. And so they would be completely beholden to the whims, that would be a nice Madisonian word, whims and prejudices and passions of those legislators. And so there would be no attempt to have them adhere to higher standards of justice, fairness, equality. So do you see? But with presidential electors, they could also, the legislators could also theoretically, after an election, pass a bill and say, we are voiding the popular vote, and we, the legislators, are going to cast ballots for our state's presidential electors.
Yeah, that was the specific scenario that I had in mind, and I just wondered if that applied to this case.
Yes. Well, I mean, that's the implication. That's the implication. That's why it's a very important case that is, as I've tried to say, I understand it's really obscure and difficult, but more people need to understand and know the stakes here.
Okay, so I've got Alan over here, there are people over here, but I couldn't see because of who was over here? Was it could you, I thought there was somebody behind there, but again, for some reason, the all white PowerPoint reminded me.
I also don't want to step too far outside your area of expertise. I also don't want to open up a massive can of worms.
This is a can of worms, so you're not opening it up.
You did mention a couple times, I do want to kind of talk about the Electoral College. You know, you mentioned earlier in the lecture that there needs to be a delicate balance of power between national power and state power. And the way I understand it, and the way it's originally formulated, that Electoral College was one of those institutions of balancing power between. So without the Electoral College, what would be in its place? What would be that kind of defining balance between national and state power in terms of federal elections?
Well,
What's the alternative?
well, popular election of the president, in which what happens now, and in another PowerPoint, I have a good drawing of this, you know, as it happens at this particular moment in history, because the states get 2 extra electors just because they're states, and because there are a lot of states with fewer people but get those 2 extra electors, and those states happen to be Republican right now, it gives extra weight right now at this moment in history to Republicans. And so by taking that away, it would just be, you know, the popular vote of the people, however that would turn out. And we know that that would have been turned out and made a different result in the election of 2000 and 2016, right?
I could follow up though.
Yeah.
That could change theoretically over time.
Yes, I mean, and that's why, you know, it's why it's important to have principles that don't just vary according to your political beliefs. Because theoretically, okay, let's just say a lot of generation, what are you, Z or whatever, moved to Idaho and Montana and Utah, and those states suddenly turn blue, and all of a sudden, you know, the Democrats have, you know, the added weight in those states given by the extra electors. So it's not, it's this, I mean, you got to think about the system preserving the power of the states as opposed to just majority rule. You know, I mean, personally, and this is not a popular view, but I sort of like federalism. You know, I sort of like it, even if it doesn't always give the results that I would like.
Alan.
So, one thing that I would say you might want to look at is Texas, even in the 1990s or 2000s sometime, redistrict, I believe it's federal representatives, independent of the census. So in between years, they redistrict their members of the House. This is the one where the Republicans got on the bus and went somewhere and the legislature was left empty and all this crazy. It was a crazy scenario. There must have been protest to that. There must be case law surrounding that is exactly the same.
Yeah. Yeah, I don't know. I mean, again, it's not a lawyer, but that's a good point.
Well, the other thing that I would say, the question is, basically, who is the state legislature independent of, and who gets to do the rejudging? And so it's really kind of you. I'm 1,000% with you in terms of where you're going. But you've actually raised my concern that the Supreme Court might say, and this is part of what Bill's pointing out as well, they might say the state legislature is independent with regard to that particular state. And if Congress wants to, they can come in and establish uniformity. But otherwise, there's nothing that can be done about that.
You're very right that this Supreme Court might very well say that.
Okay, that's a fail to our cause.
Grant's had a question. Yeah. So definitely in light of the recent EPA decision with the Supreme Court, guiding federal agencies and regulatory powers, there seem to be at least 3 justices that are well into dating the Independent State Legislature Theory, and I think 2 at least would go out for drinks with it. So there's like a very real.
That's my reading too, yes.
Yeah, that there's a very real chance that maybe perhaps we see some activist judicial philosophy take place. Some would argue that this is just a response to activist judicial philosophy on the left, with substantive due process and things like that. I was just wondering, with your knowledge of the founding of this country, was the idea of a runaway judicial branch a concern at any point ever?
You know.
Should Jefferson
No.
was concerned about?
Jefferson?
Sure.
Really? Yeah.
It's that whole book that Jefferson.
Oh, yeah, Hamilton said he wasn't. I mean, I do not think they would have anticipated, you know, they didn't have a full-fledged concept of judicial review. They were working out the implications of what it meant to have a written constitution as fundamental law. They were just figuring out what separation of powers meant for, you know, overseeing the court, overseeing the legislative branch. So I just don't think they could have anticipated this kind of judicial activism, if you want to call it that, on the left or right. I just don't think they could have. What did Hamilton say? Judicial branch is the least dangerous branch? That's what he said.
I mean, I think part of what you're, according to Jefferson and some, I mean, judicial review itself is a runaway judicial, right?
Yes, yes.
No, that's the creation, the erection of an independent force. Independent branch and government. Well, right. So, but it doesn't necessarily. So it's this is obviously it's running away, way away. But go ahead, Gordon, and this is probably the last.
I just want to clarify. First of all, the Moore versus Harper and the Independent State Legislature Theory are confined to presidential elections. Is that correct, or are they claiming authority for other?
The case itself is about
the
North Carolina State Court's authority over the North Carolina legislature on this matter of redistricting for election of members to the House of Representatives. But if they decide to use as the basis of supporting this reasoning, the Independent State Legislature Theory, it opens up a whole can of worms.
Beyond presidential elections.
Beyond redistricting, beyond presidential elections.
But the only thing in the Constitution they're pointing to are these articles
Well, and there's over 200 years of precedent.
and
I mean,
precedent. And
frankly,
I mean-
that's the strongest argument, I think.
But-
Precedent is the strongest argument,
the pro-independent state legislatures, this is all they've got.
and those couple of
And a
cases.
couple
I
of
mean,
cases. When I read Article 2, Section 1, it doesn't say the state legislatures can appoint the electors. It says the state shall appoint the electors in the manner chosen by the.
As the legislature may direct, as the
in such manner as the legislature.
as
may
the
direct.
legislature.
Yeah, it's sort of clear. So there. but that's-
Textual, text.
That's all illegal work, so never mind that.
So a couple more questions broke out. Jay, or would
I just wanted to ask you a question really about the difference between doing history and then using history in a contemporary legal set of arguments or environment. Because you're doing history wonderfully, as we all have responded to. But it seems to me that it is just really hard to respond to a highly literal textual argument if they just point to legislatures. It's just going to fixate on that. I guess you had two ways to respond to that. The first was just to more forcefully reiterate this very capacious argument. I mean, you're coming from lots of different directions. But then secondly, that when you had synonyms and that sort of thing. And I guess I wonder how effective is that as a
We'll see. I mean, you know.
And then is there a third way? Is there anything else that you can do to respond to it? A very textual, because that's not a historical argument at all. Really, that's a legal, a contemporary legal lens on history, which I think is quite different.
Right. So I'm somewhat uncomfortable doing this, I will confess, because I don't believe in originalism. I don't believe in textualism. I don't believe in, a literal interpretation of the Constitution as, as a way of, as a method of constitutional interpretation. But I feel that the stakes in this case are really high, that the understanding of the historical circumstances are sufficiently obscure, that they need to be better known, and that certain judges and lawyers and citizens should be aware of the history and aware of the stakes, as I've said before, and what will be lost if this independent state legislature theory is validated in any sense. And so, as I have said, I really think the fact that this has not been the way the Constitution's been interpreted for over 200 years is the strongest argument. But I think that for some justices who may be just coming to this argument or trying to think it through, or their clerks more likely, maybe some of these historical arguments will resonate in a way that will be persuasive. But, we know what happened in the Heller case on the Second Amendment. We know what happened. The justices don't have to pay attention to history. The Supreme Court justices, they don't have to, and they may not. But I think that I feel personally that the stakes in this case are very high, and that it's interesting. One of the things that came to me as I was writing this, which I hope gets published as an article, historians even of the founding period are not necessarily presentists. They're not necessarily trying to answer present day questions, but we still have our assumptions and we still have our interests shaped in some sense by the present day questions. And so when I went looking for the evidence for this, really nobody laid out, what the genius of this independent state legislature theory really is that nobody's paid attention to the literal reading of the Constitution in this way. And so historians haven't bothered to try and explain why it's wrong. And so it just occurred to me how subconsciously even historians, what we see in the past, what we look for in the past is so much shaped by our present day circumstances, even when we're not deliberately trying to like argue against a present day theory, Supreme Court theory or something. So that's my thought.
I think once this YouTube video is out, it'll just be scoured from you. Tara, do you get the last question?
Okay, so Jay mentioned, is there any way to kind of rebut this or push back against it textually? And just looking at it, it seems to me like if they point out the word legislature, couldn't you point at the word election? You say, well, elections are things with a real meaning, and elections, the outcome isn't predetermined or rigged in the way that gerrymandering tries to do. And elections are determined by the votes of people who are eligible to vote in them, not some kind of intermediary body that looks at them and says, we don't want that outcome. And so it seems to me that just on quite a spare understanding of what election is, you can stay within the text, but have some kind of control for what the legislature has to work within.
I like that. Yeah, I like it. Yes.
Yeah.
I mean, I guess I would say I was trying to make a version of that argument by saying that you can't have elections, you can't have a legislature making laws without the state constitution.
Right. Yeah. So I think that supports you. It's
Yeah.
the meaning of election.
Yes.
Okay, well, I think that's a good place to stop. I don't know how much food there's left.
Thank you very much.
I think there's the food out of the corner of my eye. I know there's beverages around the corner. So thank you. And
Thanks a
there's
lot.
something next week. But if you wanna- all right.
Tell your friends and family.